Welcome to our Small Firm Survival Strategies webinar. My name is Frank Musica. I'm one of the risk management consultants here with Victor Insurance. Now, we will be talking about the many challenges of small firms. Small firms, whether they're sole practitioner firms, small partnerships, or corporate entities with few owners, face a multitude of problems. There are the many difficulties in setting up and operating the business, including dealing with not only licensing laws, but practice regulations, avoiding the missteps that could result in bankruptcy, and looking at what a small practitioner might consider as a preferred future for the firm. This program will quickly run through some of those risks, so let's look at what we will cover. Now, these are the 7 issues I want to cover. Firm organization and development, pursuing clients and projects in an ethical manner, negotiating reasonable professional service agreements, including in those agreements billing and collection procedures for your fees and reimbursables, and establishing productive and safe interprofessional relationships with your subconsultants. We'll also look at maintaining professional integrity and reputation while you're operating your business. But the emphasis will be on the 6th bullet, facing professional liability and business risks. And I will try to give you a better idea of the difference between professional liability exposures, your tort law exposure for harm caused by your failure to meet the standard of care for the professional services you perform, and your contract and other business liabilities. Here's the first issue. Always realize that you are running a business. Some design professionals think that once they are licensed, they can provide their services to the public. They ignore the business authorization issues. And some small firms think that they are licensed in one state, they can advertise their services in other states. Remember that the United States is not united. It comprises 56 state and other jurisdictions, each of which has its own laws and regulations. So don't think you can practice with impunity in a state where you are not licensed and authorized to perform services. You might end up in a situation where you give away your services because you cannot lawfully collect a fee. And please do not think that if your tax advisor has set you up as a limited liability operation, that your assets are protected. Your professional liability is not limited by any corporate structure. Both the firm and the individual are at risk. Even your business risk can be on the individual signing a contract, since vendors will ask for a personal signature as well as a corporate one. I'll talk later about your legal status as a professional. It provides both the protection, but also holds you out for greater responsibility than a retail business. Understand your ethical requirements. You can even use them when negotiating a contract to avoid things like blanket certifications. Now, although restrictions on advertising by professionals were lifted decades ago, which is why you see constant, if you have a phone, you have a lawyer ads, be careful in how you advertise. Saying you are the best professional is usually considered puffing and does not establish a warranty. The stating on your website that all of your projects come in on time and on budget is a claim waiting to happen. Even if something is not a contractual guarantee, it can create expectations that will lead to claims. So when you advertise or otherwise promote your business on a website through presentations or through podcasts as well, keep in mind that you might be misunderstood. And remember that pre-contracts not only create expectations, but are often incorporated by reference into the contracts. So make sure that you clearly indicate that the contract governs and not what was in the proposal or study or any other document prior to the contract. Your scope and the terms and conditions that are in the final contract are what the client should expect and what you should provide. Now, I know that using AIA or HACCC contracts can be expensive, but they have value and can address the significant issues of a contractual relationship with language that has been clearly construed through litigation. If you do not use a standard AIA EJCDC, or if you're a landscape architect, ASOA contracts, study samples of them and learn why the language is important. And find a local attorney who understands transactions in the design industry to provide you advice, including looking at laws in other jurisdictions that might govern your contract. Do not expect legal advice from your insurance broker or insurance carrier. They cannot provide legal advice lawfully, nor can they provide anything more than basic examples that are not specific to the governing laws. We provide through our website many contract negotiation tools, but they all state that you have to have jurisdictionally competent legal advice. When your client comes up with unusual contractual obligations, make sure you ask why to determine what is the provision's intent and clarify any language you or your client might not understand. And always be ready to walk away. If they want your services, they will negotiate, but don't become a target for cost recovery litigation because you accepted a bad contract. Now, from my decades of practice, I know that not getting paid is the greatest risk you have. Some clients seem to think that a payment for services is merely voluntary. And one problem that small firms face is making sure of the authority of the person signing a contract or serving as the client's contact. Do not allow yourself to work for a client's representative who cannot make decisions or authorize payments. And for smaller firms that do residential projects, make sure that both owners of the property are signing a contract. If there's more than one owner, you may end up in a situation where one party signs a contract and the other one makes a decision on whether or not you're going to get paid. And be fearful of any contract that allows a client to decide to withhold your fee arbitrarily, especially if elsewhere in the contract, the client combines that with an automatic transfer of rights to anything you create and tacks on a prevailing party attorney fee provision, because that triad is a clear sign that the client may stiff you on a fee and even coerce you into surrendering or even paying for a loss the client wants you to absorb. Make sure you have a proper billing procedure and enforce it. And don't get too far ahead of your collections or you will lose any leverage you have to recover your fee. And do not fear suspending services if payments are late. You have to have a suspension of service provision in your contract. And realize that you are responsible for any sub-consultants you hire. You have vicarious liability for their actions. And in a bad contract where your client separately hires sub-consultants, you might have a manageable coordination liability exposure, even if you have no control over the sub-consultants. So be careful with sub-consultants. Is the sub-consultant insured or able to indemnify you from its assets as the prime? Has the sub-consultant's liability been limited so it does not have to stand behind the harm it creates because of a professional or business decision deficiency on its part? And look at these issues on limiting the risk of your sub-consultants. You never limit your the sub-consultant's liability if you don't have a limitation of liability by your client. They should be to the same amount. Now, maybe there's some situations where limiting the subcontractors or sub-consultants' liability is reasonable because the service is minor or the fee is minor. You might consider that, but remember, you're going to absorb any losses above that limitation. And understand that it doesn't have to be a limitation to a specific amount. It could be through a waiver of consequential damages, where the subconsultant no longer takes responsibility for the many costs that could lead from its negligence, or a waiver of subrogation rights. So you have no opportunity to go after the subconsultant for the subconsultants' deficiencies that cause losses. Now, if the subconsultant wants a limitation to require the acquired amount of insurance, remember that limit might not be available at the time of a claim because that limit may be eroded from other claims by the subconsultant. And also keep in mind, if there are unusual risks of the subconsultant services or the owner picks the subconsultants, are you as a prime compensated for the extra exposure? And now I want to give you a basic education in law by addressing these 4 points. You have to understand how the law works. Common law, statutory law, licensing laws, they can both protect you, but they also hold you to a higher standard. And you are running a business that just happens to provide professional services. And every business has uninsurable risks. Some small firms ask, well, isn't my professional liability insurance covering this? No, you have many other business risks that professional liability insurance was never meant to cover. And appreciate that you have both that professional liability based on tort law, that's what your insurance covers, your professional liability insurance, and business liability based on contract law. So you need to have the other types of insurance as well. And recognize that your assets, your money, and your reputation are always at risk. Now let's talk about why design firms are often targets of claims. It really comes down to 2 things about a law in the United States and 2 things about design practice. The law protects reasonable expectations, and you are responsible for whatever the foreseeable cost of your wrongful conduct is if you're not carrying out what the law expects of you. Now, with design practice, it's all about trade-offs. Everything you do in design is using your judgment. And in the design that leads to construction, the trade-offs are all about money, time, and quality. If you do not have a sophisticated client or do not educate your client and communicate with your client on a continuing basis, the differences in expectations and the realities of practice can lead to misunderstandings, and misunderstandings can lead to claims. Now, first, you should be aware that you are subject to tort law. This is the application of the standard of care. The comparison of what you did to what others in the profession might have done on the same project type, in the same location, at the same time. It is an analysis not if what you did was right, but rather if what you did was reasonable. It provides protection to you as a professional because of that standard of care. Now, contrast that with contract law. You can assume contractual obligations as long as they are not illegal. And in doing so, you create private law between you and your client. That private law might reduce the protections of tort law and expose you to risks that you cannot manage and cannot insure. Let's talk about tort law. This is what professional liability insurance covers. It is determined first by deciding negligence. Was there a breach of a duty? So the question is, was there a duty that existed to your client, to a user of a facility, to a passerby of a construction site? And was the standard of care for your professional services met? And there is a determination as to whether the breach of a duty, your negligence, led to harm. So the issue is the proximate causation of a foreseeable harm. Okay? If you breached the duty, you were negligent, but you might not be liable. Is there damage that can be traced to the breach? And could that damage have been expected? And here are sources of duty for a design firm. There's common law duty. That's what's expected of you as a professional. There's statutory law. What does the law require of you as a professional? And there's contract law. What did you promise this specific client? But while tort law is based on common law, and to a certain extent on statutes, contract law is based on the promise you made to the client. Now, with tort law, the standard of care for services is important. If nothing is said in a contract about the level of performance, the normal expectations of performance as others in the profession would perform is assumed. But you can change a standard of care, and that can be tricky. If, for example, you state that you will meet a standard of care applicable to engineering firms experienced in the design of dams, or the standard of care applicable to architecture firms designing hospitals, you have raised the standard of care you must meet. But that does not jeopardize your professional liability coverage. If, however, you state that you will design to the highest standards, something that cannot be measured, or that your design and design documentation will be fit for the purposes intended, you are probably providing an uninsurable guarantee. And remember that unfulfilled expectations often lead to claims. So you need to manage those expectations from the time you first work with the client until the project is closed out. Remember, I said you can make private law with your client. Now, for a client to exist, the questions are basic and are these. Was there an agreement between the parties? And if so, was there consideration that makes that agreement valid? Was there a promise to pay for services? Was there an exchange of money? Was there exchange of promises? That's what is meant by consideration. Note that there is no mention of the standard of care or determination and negligence. So if you have a valid contract and it was breached by your firm, you are going to be responsible for whatever remedy is appropriate. And your professional liability insurance does not cover a breach of contract unless the breach was caused by your negligent performance of professional services. In that case, the breach of contract is not covered. The underlying tort liability is covered. Now, a special form of a contract is a warranty, and these are the elements. Was a promise made? In a project leading to construction, it's often about time, cost, result, and related to your services. Was there a right to rely on it by the person you're offering the warranty to? Did the party actually rely on it? And did the promise prove false? And if that reliance was justified, then what harm was caused by that reliance? And then what remedy is adequate? Again, notice that no breach of the standard of care is needed. It is simply a promise that proves to be false, causing harm. And such contractual promises are not covered by professional liability insurance. You also need to understand the extent of your exposure, and not just for professional liability claims. First, who can recover? It depends on whether the harm was caused by your negligence, including your negligence in the performance of professional services, or your breach of contract, or whether the exposure is based on a breach of warranty. If it's negligence, anyone harmed by it, the person falling down the steps that were improperly designed, your client who, because of your negligence, can't open the facility on time. Those are negligence that creates a possible recovery for anyone who is harmed. By contract, it's anyone who's in privity of contract with you. That's your client, but there also could be third-party beneficiaries. So look for those in your contract. You don't want to extend contractual rights to a multitude of parties. And with warranty, anyone with justifiable reliance on that warranty statement you made. Now, how much can they recover? Well, there's direct damages. That's easy. That's usually something that is simple. If you misdesign a structural element, it may be the cost of redesigning and replacing that structural element. But there's also consequential damages. Did misdesigning that structural element delay that project significantly, causing costs to the contractor, causing costs to the owner? Because those are consequential damages that would flow out of your negligence. Now, what can they recover? Well, they look for your insurance, which is why you carry insurance of all kinds, but they can also look at your business assets, and in many cases, they can look at your personal assets. And depending on the type of exposure, your peril can last for years. In most states, if you're performing professional services that lead to construction, you might have the protection of a statute of repose. This is a statutory limitation on how long someone who contributed to the improvement of real property could be held liable. Now, they were put in to protect contractors, but usually serve to protect design firms as well. And they can last, they can vary in their timing from 4 years to 15 years, depending on jurisdiction. A few states have no cutoff of exposure. But remember that statutes of repose do not apply to every service design firms perform, because they have to lead to the improvement of real property. Now, there are statutes of limitations as well, which are measured after harm actually happens. So if there is no statute of repose and that harm actually happens 20 years down the line, and that's when it's discovered, that party who is harmed by that may have 2, 3, 4 years, depending on the statute of limitations, to bring a claim. And remember that in most states, your contract can further limit or create unlimited time for recovery. Up until the 2007 AIA contract, there was a standard provision that said the statute of limitations starts at substantial completion. So what that meant is it really created a very short statute of repose, because it's not from the discovery of harm, it was from a certain date, substantial completion. Now that limited the rights of the owner, because it was a contract between the owner and the architect, to bring a claim. Owners did not like that, they saw through that, they protested that, and it was taken out of the 2007 documents and documents since that time. But that is one way contractually that you can limit your risk. But a client can also say, it doesn't apply in this case. That statute of repose does not apply. And therefore your risk could be limited because you agreed to have your risk limited. Statute of repose often do not apply to government agencies as well. Now, you know that even on the simplest projects, there are risks. The risks of not getting paid being the greatest. And when you run a firm, you have to identify the risks and plan for dealing with them. You assess those risks and you try to manage those risks. You may ask for more compensation because of the risk. You want to balance those two. You may have to modify your risk management techniques. You may have to increase your capability by bringing in someone. But one of the best ways to focus is focusing on communication and documentation. That even helps you prepare for unanticipated risks, because stressing communications with your client can keep your client aware of what might happen. The more you keep your client informed and involved, the less likely that an unanticipated risk will be blamed on you. With all risks, not just professional liability exposures, there are these 5 standard techniques to deal with the risk, and we will look at these in more detail. First, retention. You can retain risk, but of course you should realize you are doing so. You might do so because you want to establish a track record with a specific client, or you want the publicity of doing a specific project. But if you have to look at both the possibility of a problem and the probability of a major problem occurring when you decide to gamble on an exposure. You might take on an exposure project that is risky, but you think will provide compensation to keep you in business. Deciding to put immediate cash flow ahead of future professional liability claims can be a significant risk. But you always have to think about your skill set. Can you do that project? Your capacity, do you have time to do that project? And your ability to manage that risk. There is always the possibility of avoiding risk. The most certain way of doing this is to do your due diligence on the client, the project, and the outside factors that could affect your risk. Walking away from a project is not an easy decision if you do not have a backlog of projects to keep you in business, or otherwise do not have confidence in your cash flow. But from my experience and practice, I can tell you that it is prudent to turn down some commissions. The allocation of risk on a project is usually an attempt to place risk with the party in the best position to manage that risk. So if there are unique exposures on a project that your firm has no ability to manage, it makes little sense to allocate that risk to your firm. But as a small firm wanting to serve a client, you might have the ability to actually manage an exposure. And if you are assigned the authority on behalf of your client to manage that specific risk and are being adequately compensated to do so, you might take on the risk. Often small firms with unsophisticated clients take on greater responsibility during the construction process. That is not a professional liability coverage issue, but it might be a heightened exposure, so make sure you can handle it and you're getting paid for doing so. You can attempt to transfer some of the risk on a project. That's what you do by buying professional liability insurance. And normally, if you are a smaller firm, you have to rely on a practice policy. Project policies, which are usually paid for by the client, are seldom available on anything other than very large projects. But in a contract, you can also transfer some of your risk. While most contractually assumed indemnity obligations favor your client, who wants to transfer as much of the client's risk as possible to you, but you also can be indemnified or even defended and indemnified by your client. Good example of that, we had a firm that was designing a tiger exposure for a zoo. It was relying on information provided by the zoo for the design parameters for that project. But it knew there could be immense risk in doing that project. Someone could fall into the tiger pit. The tiger might escape. So it had the client both release it from any claims from the client and promise to defend and indemnify the design firm from any harm that could happen because of that design of the tiger pit. So if the tiger escaped, the firm would not be at risk from third-party claims if the tiger caused damage. You can also limit your liability. We'll look at many forms of limiting liability in a while. And if you are using a standard AIA contract, you should know that the current B101 has probably a dozen limitations of the architect's liability built in, not to an exact dollar amount, but there are other ways you can limit your liability. Now, on every project you take on, you consider ways to mitigate or lessen the exposure. Here are some examples, right? You may have a client or who needs extra handling, or a project that needs extra attention because it's a different kind of project. You may add special skills on your project team. This happened with when we started doing sustainability, green design, where firms would hire specialists to help them. You always have to be careful in your enforcement of practice management systems requirements. You want to make sure you're following your own internal rules. And you can always try to mitigate risk by establishing a non-adversarial approach. You want your contract to talk about meeting and conferring with the client if any dispute happens, or negotiating the settlement or mediating the settlement. You want to try to avoid adjudication, which is either arbitration or litigation. because that becomes adversarial very, very quickly. There are other ways to mitigate your risk too, and your contract is a significant device to lessen your exposure. Look at these top three: having a clear scope definition in your contract, time limitations that are reasonable, and payment terms that are clear and enforceable. But I also want to point out the fourth bullet. Please remember, if you are a sub-consultant or the prime consultant on a project, you should insist on insurance information from the other team members. If you are a sub-consultant, you probably have to provide insurance information to the prime, including a certificate of insurance. That's a snapshot of your coverage at the time it is issued. But you should also understand if the prime has coverage for the assumed exposures. For example, if you are working for a design builder, often a contractor, even though that design builder has responsibility under state law for the design, there might not be professional liability coverage in place, and the design builder will essentially transfer its legal risk to its design sub. And perhaps the best way to mitigate your risk is to have a system in place to document the project extensively. You have to create a contemporaneous record of the facts on a project, including all the communications that affect your services. And remember, never document an opinion or a hypothesis about a problem on a project. You can always use facts to later develop an opinion, but you can never produce facts from a recorded opinion or conclusion. And once you create the contemporaneous record of the project, you have to preserve it. Notice that I did not include video records in the list of formats. You can call and keep specific photographs, but do not keep any video of a project site unless you are required by the contract to analyze the video. And even then, you might document specific events in your notes from that video and discard the entire footage. Never accept project site recordings from a contractor or your client unless you have the contractual obligation to review them. And even then, you must be specific as to the purpose of the review. Otherwise, something in the video record might be found during discovery and held against you under the argument that as a professional, you had the duty to recognize the problem. And keeping information as long as the applicable statute of repose, if it applies to the project, plus a few years because there is usually a statute of limitations tacked on to the repose period. And that's the usual length. Remember that a document preservation schedule that you create is actually a document destruction schedule. So if you have one, follow it. Call the file before you retain it, and only keep it for the period that you said you're going to retain it. Now, keep in mind that if a claim occurs right before you're going to destroy a file, you cannot destroy the record, even though your schedule says you should, because that would be spoliation of evidence and could be held against you in court. I think we have already talked about the value of having a well-crafted contract. Contracts can change the standard of care for your services or otherwise modify your normally insured professional duty into an uninsurable contractual obligation. And always be aware of provisions in the client contract that puts a bullseye on you for future cost recovery efforts. Owners do that because they know that a breach contract is a lot easier to prove than the liability of a design firm in the performance of professional services, tort liability. One problem that many small firms face is the use of oral agreements, either at the beginning of a project before a contract is negotiated or for the entire project. They are fraught with problems and should be avoided. If you have a client who wants to get started before a contract is executed, at least send the client a standard set of terms and conditions with your acknowledgement letter and require the client to authorize your performance based on that document as a reference. It might not keep you from having to negotiate a contract with owner's terms and conditions later. That's often done by a contract because by that time you have too much invested to stop services. But you need something that sets the standard for the relationship early in a project. And don't sign a final contract with terrible terms and conditions just to get paid at the end of a project. That's a negotiation ploy used by many developers. Chances are that contract will have the ability to cause you harm to you later. You might find your firm working for an organization that wants to treat you not as a professional, but rather as just another vendor, and issues a purchase order for your services. Unless a purchase order actually is focused on professional services, and that is rare, you will find your firm trapped into meeting product liability standards and providing unmanageable and uninsured warranties and guarantees. Some small firms have said that the owner's conditions are simply boilerplate terms and would never be enforced against the design firm. But that is a gamble you probably do not want to bet your firm's liability on. I mentioned that we will look at limitation of the liability options. And for decades, the standard AIA and HACCC contracts have contained various forms of limitations of the professional's liability without having an absolute limitation for business or professional liability. Perhaps the most successful and easily accepted limitation is the exclusion of consequential damages. It was added in 2007 to both the owner-contractor and owner-architect agreements by the AIA Contract Documents Program. Owners sometimes accept this because they value its reciprocity. With construction contractors, a reciprocal waiver of consequential damages makes sense because contractors can sue owners for significant damages for any delay. But with design firms, such a waiver really only benefits the design firm, since the design firm is unlikely to ever recover consequential damages against the client. But clients may not realize that and accept it, so it's for your benefit. Now, you can always try to limit your liability to corporate resources. In some states, like in Florida, that has to be done very carefully in using special language and a special font size. You can limit your liability to reperformance of services. Often that's what a client wants. Do it again and do it correctly. You can limit it to the amount of the compensation you receive, basically giving back your fee, or to a specific dollar amount, which some clients may accept, but clients relatively do not like that specific dollar amount. Now, available insurance proceeds, always make sure that you're limiting it to available insurance proceeds, because if it's just what's stated in your contract that you have to carry, you could be responsible for an amount above what your insurance could cover because your aggregate limit in that policy may have been eroded by other claims. You can limit it for a specific risk, like in that tiger pit example, on a comparative basis, only responsible for the harm I actually caused, or for something called a safe harbor provision. That's a situation where you can say, you can agree with the client that no claims will be brought against you unless the amount of change orders becomes a certain percentage. Now, that's a tricky thing to do. It used to be part of a standard EJCC contract, but what owners would do was simply change the language in it. So anything over a certain amount of change orders was automatically the liability of the engineer. If you have a safe harbor provision, you want it to keep claims away from you until a certain amount of change orders is authorized. And then you only want to be responsible for the actual damages caused by the change order if the change order is required because of your negligence and your performance of professional services. Now, if you are a policyholder, there's more on their website about limitations of liability. Insurers like absolute limitations because they benefit the carrier more than the policyholder, but they can have value for both if they are used as a lower starting point for settlements. There may be a situation where the client thinks, well, I have a 50% chance of recovering that specific dollar amount that I limited the risk of the design firm to. But if I only have a 50% chance of recovering that, I might take a lesser amount. So in the negotiation process for a settlement, you may start at a much lower point to solve a problem. Now, you will see many clients demanding contractual indemnity or defense and indemnity obligations from your firm. It often makes the client's recovery much easier than suing you for your negligence. And they often cover perils that have nothing to do with your performance of professional services. And they might make sense for the protection of a client. Obviously, if for instance, one of your employees sues the client because it was harmed on the site, that's something your workers' compensation should cover. And the client doesn't want to be sued for that type of an injury. Promising to indemnify the client against those kind of claims from your employees probably makes sense. And you may have employer's liability insurance that covers that. But from a professional liability insurance coverage perspective, remember that your policy covers your liability in the performance of professional services, your tort law liability for not meeting the standard of care, and any contractual obligation beyond that is not covered by your professional liability insurance coverage. So this language highlighted basically generally states your normal legal liability and performance of professional services, and therefore the exposure covered by professional liability insurance. And remember that the language of such a provision is often created based on the applicable state law. So when you see extensive language, you need advice from jurisdictionally competent lawyers. The copyright laws give you protection for your intellectual property, whether you register the creative work with the Copyright Office or not. The remedies differ, but the protection is in place once a creative work is published. But you can always transfer your ownership in the instruments of service, the copyright to the instruments of service, and even the copyright to the design of an architectural work. And rarely does doing so create a professional liability claim against you as the original designer. And the few claims that appear are usually defensible. The real issue is leverage. If you give away your rights before you are paid for the services that created the instruments of service or the design, your chances of getting paid are reduced. Usually a license to use documents is sufficient for most owners, but the client wants full ownership of the actual documents or of the copyright to them, or even the copyrights to design. Make sure you are paid and negotiate protections from misuse. There is more information on our website about this. And if you wonder why the term for your documents is instruments of service, it is because before the law changed in 1976, project documentation was automatically transferred to the client as a work for hire. And the term instruments of service was created to differentiate what you do from the list of what constitutes a work made for hire. So it's clear that you provide professional services and not plans and specifications, since they are only there to convey your creative services. So you might see an owner's provision that denotes them as works for hire. But because that may not be the case, that kind of a demand is usually accompanied by, if they are not so considered, the design firm transfers all rights to the copyright material. Again, you can approach this carefully. It doesn't end up with professional liability claims, but it could destroy your ability to get paid. Now, you know that projects in the United States routinely go over budget and take longer than planned. In both of those situations, the cause is usually overly optimistic projections of time and cost. With both time and cost, there has to be a realistic assessment and a recognition that things happen that could cause delays. So educate your client and do not agree to time limits that do not make sense or are not in your control. Make sure that time is included for your subconsultants to be able to provide their services. And remember that all professional liability insurance policies exclude from coverage liquidated or predetermined damages for delays in meeting milestones or in the project's completion. Professional liability insurance pays for actual damages to the extent they are the result of a negligent performance of professional services, while liquidated damages are absolute amounts based on absolute timelines. Now, it could be that any liquidated damage amount was the result of negligent performance, and the amount is actually less than actual damages. And in this case, they would be covered by your professional liability insurance policy. But remember, in almost every instance in every state, the payment of liquidated damages does not preclude a client from also seeking actual damages based on your negligent performance of professional services. Now, you might be faced with a client that does not want to pay you for the normal services you provide during the construction phase, or they might pay for office services but not field services. From a professional liability exposure perspective, it is important that you provide services during construction. Otherwise, all fingers point to you when a problem occurs and you have no control over the exposure. Clients should understand the value you provide during the construction process. So avoid situations where a client just wants a builder's set of insufficient documents or wants you excluded from the construction process so changes can be made to the design without your involvement. Communicate to your client that your services are important to protect the client's interests on a project because you serve as the client's representative in administering a contract between the client and the contractor. If you are not going to be there, negotiate protections, and that has to happen in the contract negotiation stage. It will not happen if the client has the ability and simply decides to terminate your services. Now, on every project, the construction contractor takes some element of control over the site. And because of that, it is the contractor who is responsible for site safety. And when a contractor bids on a project or negotiates with the owner based on the documents, that contractor takes charge of the construction means, methods, techniques, sequences, and procedures of the construction process because the contractor has the right to build the project in the most efficient way for that contractor. That does not mean that design documents must avoid specifying means, methods, techniques, sequences, or procedures, but any construction instructions must be provided before the contractor sets the cost. So your job should be to evaluate the work based on the commitments made by the contractor in the contract documents for the project. You don't tell the contractor what to do or how to fix a problem. Otherwise, the risk shifts to you, and the contractor has the right to ask for more money because the efficiency of the contractor has been jeopardized. Now, shop drawings are communication tools. They and other submittals are not part of the contract documents. They are ways to see if the contractor understands the requirement of the contract documents. Now, some firms call for few or no shop drawings and leave it up to the contractor to meet the requirements of the contract documents. But if you do require shop drawings, keep these points in mind. There has to be a required schedule for the submission of shop drawings, and there has to be the allowance of time for that review. Right? You do not want to be dumped on with a bunch of submittals at one time on a Friday night and be expected to have them reviewed by Monday. So you enforce the submittal and review schedule. Now, one thing that standard contracts do is require the contractor to check and approve any shop drawings before they are sent to the design firm. As you know, most contractors simply take shop drawings from subcontractors and send them off to you without ever looking at them. That should be avoided, and you do that by having the contract say that the contractor has to check and approve them. Now, if a shop drawing comes to you that you've never requested, reject it. Have on your stamp that that's not required and was not reviewed, send it back. And have someone qualified and familiar with the project and schedule requirements provide the review and document the process. Now, one thing that keeps coming up on shop drawing stamps is an old marketing campaign from another insurance firm that said, oh, never approve a shop drawing. Always say you just reviewed it and you returned it, right? That doesn't make any sense at all. If you request a shop drawing and you look at it and return it, you've approved the shop drawings. And case law constantly says that. In fact, the insurance company that said reviewed rather than approved stopped providing that advice decades ago when court decisions ran against it. Some firms still use it. It doesn't provide any benefit whatsoever. Now, part of your field services during construction is site visits. They are basic to your evaluation of the work. It is important that you document why you were on the site and what you observed. If you use photography, you must be careful. You only photographically document what you actually examined, not general pictures of the project, because they might show problems that you did not examine and serve as documentation that you should have observed the problem. So either close-up shots of specific things that you reviewed or distance shots, but not look around views of the project. And it is vital that the photographic evidence is culled before specific photographs are filed in the project documentation. And remember these issues. Visits should be determined on a rational basis, right? So specific as to the procedure. It may be when a roof is being put on. It may be when the concrete slab is being poured. But it should be defined and they should be limited in scope. The purpose and number of visits should be negotiated. And if there are few visits, it should be clear that that's all you're going to do. You do not use the term periodic visits because that means you have to go out there at a regularly scheduled time. That's never in the client's interest because that makes it awfully easy for a contractor to simply hide anything that might be deficient and not meeting the contract documents. You never use the term as necessary. That's a target for litigation is lost because obviously if something went wrong on the site, you weren't there as necessary. So visits should be documented contemporaneously and indicated as carrying out specific duties. So when you are on the site, you're there as a representative of the owner, evaluating whether the contractor's work is meeting the quality requirements of the contract documents. You can do more or less than evaluating the work, but you have to contractually agree to what level of service and what limited form of agency on behalf of the owner you will have. Right? So you clearly describe the level of evaluation. You state it in terms of value to the client. You never use the word supervision or direction of the work. Those terms were taken out of standard AIA contracts back in the 60s because that's not what a design firm actually does. Now you can negotiate and define other levels of service. You know, in a standard contract, you inspect the work at substantial completion and final completion. For years, it said that what you were doing on a site was observing the work of the contractor. That was seen as too passive because you really need to evaluate the work of the contractor. But you can agree to do other things, reviewing projects status, monitoring the effort, but only if you define those in your contract and it's clear in the owner-contractor agreement what you're out there for. When you are evaluating work, you have a duty to the owner to report non-conforming work. You can be authorized by the owner to accept non-conforming work rather than reporting it and letting the owner decide. You cannot accept work that you recognize as not meeting code. And remember, if you accept non-conforming work, you're basically changing the contract documents that are the agreement between the owner and the contractor. So you must be careful. You could even find yourself in a situation where you accept non-conforming work to keep the project moving forward, thinking that's in the best interest of the client, and find out later that the contractor wants a change order for more money or more time because the accepted work has a consequence later in the construction process. And most owners will not see that change order as something valid and may blame that on you. And again, do not include corrective advice unless the owner pays you to provide a redesign. Now, one of the most important actions you undertake is certifying the contractor's application for payment. Make sure your certificate is properly qualified, stating that the certification does not include that you made exhaustive or continuous on-site inspections or reviewed construction means, methods, techniques, sequences of procedures, or that you reviewed copies of requisitions received by subcontractors and suppliers and other data that would substantiate the contractor's right to payment because you are not the contractor's bookkeeper, or ascertain how or for what purpose the contractor has used the money previously paid. Now, some owners in their contract will identify this as a fiduciary duty on your part, stating that you are in control of the owner finances. But that is not really the situation when you certify an application for payment. So you should avoid any mention of being a fiduciary and properly qualify that certification of payment. It's an important duty, so proceed carefully and use the standard language that states that a work will be reevaluated at substantial completion. That's when you're doing an inspection. This is interpreted in most states to mean that the payments made to the contractor during the construction process were not final, and the project owner has the right to claw back prior payments if at substantial completion the project does not meet the requirements of the contract documents. And during and usually at the end of the project, you will be asked to issue multiple certificates. Do not simply sign whatever is put in front of you by a lender or other party. You should not be required to execute certificates or any consents that would require knowledge, services, or responsibilities beyond the scope of your agreement. You need to qualify any certification so they are not be misinterpreted as being a guarantee. And remember, one of your obligations as a licensed design professional is to only state the truth or offer a professional opinion based on you using your judgment applied to the facts available to you. So if you see a certification that goes beyond facts known to you or is not expressed as a professional opinion, you can refuse to provide the certification because you cannot violate the state's licensing law by providing a certification that is misleading or false. You might be asked to produce as-built documents, but that is basically impossible. You can produce record documents for the project, but you have to qualify what constitutes the information in the record documents. Is a contractor required to report changes to you, and are you just recording those contractor reported changes? Are you documenting through your observations what might have happened? You are not usually out there to verify changes. You might be paid to do so, but that's not in your normal scope of duties. And you are never actually certifying the accuracy of the information because you have no control over it. It's information provided to you. And if the owner is going to reuse those documents, the record documents, is it protecting you from any misuse of them? You should really have something in your contract to protect you if the record documents are misused on that project or for other projects. So that basically covers the contract issues that small firms have to be aware of on a project. I want to end the webinar by addressing the importance of maintaining your professional integrity and preserving and enhancing your reputation as a client-serving creative professional. Remember that as a licensed professional, you have to meet a higher standard than a contractor or vendor. That means you have a professional duty as well as your contractual or business obligations. But that status also provides you with protection because of the applicability of the standard of care to those professional services you perform. Your contractual obligations can exceed your professional obligation to meet the standard of care. And while not meeting the standard of care will damage your reputation, always remember that your contractual obligations and your general business obligations could put you in a position where your ethics and your reputation could be irreparably harmed. Value your professional integrity and practice in a way that protects it. Your integrity and your reputation as a professional are your greatest assets. So if you provide services as a small project practitioner, make sure you understand your normal rights, realize how contractual language can take away those rights, pay attention to your billing and collection procedures, and protect your professional integrity and reputation. And with that, I want to end this webinar with the encouragement for you to use our many contractual negotiation tools and practice management advisories on the Victor Insurance Risk Management website. You can reach that at www.victorinsuranceus.com/School of Risk Management. With that, I thank you for participating in this webinar.